I am told that that got some attention in Congress. And in fact, when I read the newspaper articles about the growing wage and income inequality, it's pretty unusual that there is not mention of the fact that trade union density is at its lowest historic low. I mean, it's pretty amazing that some 72 years after the Wagner Act was passed in 1935, 72 years after, there is record wage and income inequality, and the organized labor density is at a historic low. I think the lowest since the beginning of the 20th century. Somewhere I read that income inequality is the lowest it's been since 1928. So this certainly reflects, I think, a failure of our labor laws. Now, granted, there are many other factors. The economy has changed quite dramatically. The system of the nature of the employment relationship has changed radically, and our economy beginning in the 1970s, of course, changed radically, which really has put enormous strains on this model of this law with its premise of going to work for one employer for a lifetime and just going up the ranks of management. And that whole nature of the business world has become so volatile. So one day unions might organize a bargaining unit in an employer, and the next day the employer merges with another corporation so that bargaining unit disappears. So organizing is really almost an impossible task. So the labor law system operates under huge constraints. We have an antique statute. There has been congressional silence, really, on labor law for 60 years. It has not been since the 1947 Taft-Hartley amendments, which were very anti-labor, that Congress really did anything of substance to this law. In the interim, as I mentioned, there's been this whole panoply of individual rights legislation enacted, but there's been virtual congressional silence on labor law and labor policy issues for 60 years. We are in a political climate that's obviously very polarized and at best indifferent, at worst completely hostile to the concept of collective bargaining. The social mood has certainly transformed. The nature of civic activity or collective activity is in some question as the individual rights paradigm has really taken precedence. Nonetheless, notwithstanding all these constraints, it is my sense that the NLRB itself can make modest steps to try to make sure that the protections of this law are real and not illusory, can take modest steps to adapt this law to a very changing economy. I think during the Clinton board years, we made modest steps, and modest steps is really about all you can do under the statute, particularly given the courts which review our decisions and the nature of the judiciary, that reigning judicial philosophy typified by Justice Scalia, that when you look at the words of a statute narrowly and don't look at the legislative history and you don't look at the surrounding economic or workplace realities. We live in a very constrained environment, but I think there's more that could be done. And what, in my view, the current board has done with an increasing drumbeat over the last 8 years is demonstrate a lack of administrative will to make this statute work. To the extent, I think, that it reflects a basic lack of commitment to this statute, to what it means, and to what this agency is supposed to do. In case after case after case, the decisions of this board have reflected that fewer workers, fewer categories of workers are considered entitled to engage in collective bargaining. They enjoy fewer rights. The nature of what's protected under this law has been constrained. There are weaker remedies. The statute itself has very weak remedies compared to other discrimination statutes. But even as weak as can be, this board hasn't interpreted the remedies. And in case after case, the board has elevated business interests of one sort or another, whether it's private property rights, managerial discretion, employer free speech rights, whatever, business justifications of one sort of another. The board has said that those employer interests supersede the employee interests that are protected by this statute. So that if you look at the decisions, it's not just the September decisions. Anyone who had been watching the board would know that it was a steady drumbeat, certainly over the last 5 years. And any one decision may not be cataclysmic, but if you look at them in total, you see that virtually every single policy choice, when the board had a decision, had a choice what way to go. Every policy choice was one that either favored employers' interests, impeded union organization, or created an obstacle to collective bargaining. Those were the policy choices that were made. I will close just by saying that in early December, there was a joint oversight hearing conducted by a House and Senate labor subcommittees. They asked the chairman of the NLRB and myself to come and testify. We were questioned for 2 hours. And then there was a second panel of witnesses from labor, from business, from academia, and work, who had been fired in the union organizing campaign and had received no real remedy. I think, again, this hearing brought some attention to these issues, and my hope is that even though there's been cutting back or chipping away with very little public scrutiny, maybe little by little public scrutiny is increasing. I hope that you will help to increase the public scrutiny. I hope that the scrutiny will lead to a reinvigoration of these rights. I think they're important to our democracy. Certainly they've been important in our economy. And I think the stakes are too high for us just to abandon these rights. So I'm happy to take any questions.
Thank you, Ellen.
First, I'll say I thought it was a very interesting essay, and your talk very discouraging, very kind of sad for those who remember the NLRB.
Yeah, thanks for getting us all depressed.
I was wondering how it actually works. If most of your work is actually making decisions, so there's you and a Republican, does that mean every decision is simply rejected because it does not pass, or what actually happens?
You mean today?
Yes, today.
I will tell you, we're now about 2 weeks into this, and the other Republican and I are committed to the 2008 bipartisanship theme, right? So what we are committed to doing is, well, first of all, let me mention, I should have said this before, our current caseload at the board is the lowest it has ever been. I actually looked at the intake for 2007. It was the lowest in the history of the board. It was halved in 5 years. It was twice as large in 2003 itself. And this has been steadily down since the 1970s. I think there are a lot of reasons for that, but a lot of it has to do with disenchantment with the law and with the board. So part of my answer is our caseload is very low right now. What we have decided to do is to try to issue as many decisions as we can where we are in agreement. We have a decision from a few years ago from the Office of Legal Counsel of the Justice Department, which says that because most of our decisions are issued in three-person panels, 3 is a quorum of 5, because most of our decisions are issued on the three-person panel, we could have the three-person board delegate essentially to the two-person board the authority to act. So if the 2 of us are in agreement, the theory is we have the right to act. This may be challenged in some case. Some employer that loses a case before us may challenge it, and we'll find out. As far as I'm concerned, there's nothing to be lost, because otherwise the case just sits there. Yeah, I think there's an argument that maybe a court would just throw it out and wouldn't send it back to us, but I sort of think, I hope that's not.
What's the background of the other person?
The other person really does not have a labor background. He was started out as an assistant U.S. attorney. He did, I think, maybe bankruptcy practice, and then he worked with the Republican Lawyers Committee. He was with Bush in Florida. Turn the tape on. They wanted to give him something. I think he wanted to be a U.S. District Court judge, but he got stuck at the NLRB. By his own admission, he doesn't really have a background. He had started to be a labor arbitrator. He thought that was kind of interesting.
He doesn't even want to be there, it sounds like.
Well, no, oddly enough, he wants to be there. He got a second term with me. So I would have thought
there's some chance that you could find things that you agree with.
We're going to try. We are both committed to the concept, I said we're going to be judicial conservatives for a year. We're both going to interpret, we're both going to apply the law as it is. You know, not look to change the law. And of course, the change